I'm calling to order this hearing. This is a public hearing of the Committee of the Whole of the District of Columbia. I am Phil Mendelson, Chair of the Council and Chair of the Committee of the Whole. Today is Thursday, March 20th, 2025. The time is 10:43 in the morning. This hearing is being held in room 412 of the Johnny Wilson Building. It's also being recorded and will be available on the council's website, which is www.dccouncil.gov. The subject of this morning's hearing is consideration of Bill 26-45, entitled Consumer Protection Clarification Amendment Act of 2025. This legislation was introduced by me on January 13th of this year, and the stated purpose of the bill is to amend the Consumer Protection Procedures Act to clarify that the district government is not a merchant under the law, except with respect to the application of the law's landlord-tenant relations provision applicable to the District of Columbia Housing Authority. This bill, Bill 26-45, is similar to Acts 25-667 and 25-707, both of which were enacted last fall. I'll say a little bit more about that. At the council's November 26th legislative meeting, the council considered emergency and temporary legislation entitled Consumer Protection Clarification Emergency or Temporary Amendment Act of 2024. And the notice explained that the Consumer Protection Procedures Act defines a merchant as, quote, a person, whether organized or operating for profit or for a nonprofit purpose, who in the ordinary course of business does or would sell, lease to, transfer, either directly or indirectly, consumer goods or services, or a person who in the ordinary course of business does or would supply the goods or services which are or would be the subject matter of a trade practice. In prior cases weighing the applicability of the Consumer Protection Procedures Act, the District of Columbia, prior cases weighing the applicability of the act to the district, the Court of Appeals held that the district was not a merchant. For instance, in one case, the court said, we agree with the district and hold that it is not a merchant for purposes of the Consumer Protection Procedures Act. Omitting the district and its agencies from coverage under the Consumer Protection Procedures Act plays an important role in protecting the public fisc. In September 2024, in a lawsuit that was, if I remember correctly, dismissed in the trial court and appealed to the Court of Appeals, the Court of Appeals held that neither its decision in one of those earlier cases nor a reading of the code provided the district with a categorical exemption. I'm going to emphasize a categorical exemption from the CPPA, Consumer Protection Procedures Act, and the district may be liable for unfair, I'll emphasize, may be liable for unfair and deceptive trade practices under the CPPA when it is acting as a merchant. That September 2024 decision could render the district liable under the Consumer Protection Procedure Act for activities that until now were routine provisions of services and funds that the council did not intend to be subject to the Consumer Protection Procedures Act. As a result, the council, if I remember correctly, on a 12 or 11-2 vote, approved this legislation, the emergency, temporary, which are currently in effect, and the permanent that's before us today for this hearing would be the permanent change to the law. So we have 3 witnesses. The record in this matter will close at 5 p.m. on Thursday, April 3rd, which I believe is 2 weeks from today. So anyone who wishes to submit comments or supplement their comments has 2 weeks to do so. With that, let me call the 2 non-government witnesses first. LaRuby May, who is listed as a public witness. I believe she was the attorney in the case that went to the Court of Appeals, and Alex Stein. And Ms. May, since you are a former council member, I'll refer to you as council member. Good morning, and how are you?
Good morning, Chairman Mendelson. Thank you for that. But, you know, feel free to call me LaRuby. It's what my mom named me. It's good.
Well, that may be good, but at a hearing, we usually are a little more formal than that.
Yes,
Council
sir.
member.
Yes, sir. Thank you. Thank you, sir. So good morning, Chairman Mendelson. As you stated, my name is LaRuby May. Thank you for the opportunity to testify this morning before the committee on the Consumer Protection Clarification Amendment Act of 2025. But before I get started, Mr. Mendelson, I want to note that my sister, one of the plaintiffs, is here. And if it's okay with the chairman, I'll go a little bit over 4 minutes if I could just kind of essentially have her time. If that's okay with you, sir.
Depends on how much, a little
It's not
more
much
over-
more. It's not much. It's not twice as much.
Yes,
but
we don't have a long witness
okay,
list,
okay.
so
All right, thank you.
it's okay.
Thank you, sir. On November 26, 2024, as you stated, Mr. Chairman, the council passed by an overwhelming majority the emergency and temporary versions of this legislation. In the memorandum request to agendize this that you submitted to Secretary Smith, you cited that emergency action is needed to clarify that under the CPPA, the district is not a merchant except where the District of Columbia Housing Authority acts as a landlord. In addition, Mr. Chairman, you cited to the decision by the DC Court of Appeals in the May versus River East at Grandview litigation that the district may be liable for unfair and deceptive trade practices under the CPPA when it is acting as a merchant. Additionally, in support of the need for the emergency and temporary legislation, you cited you specifically identified the May litigation, which I will note for the record, that is that our plaintiffs are 6 Black women whose dream was to become a first-time homeowner. That the decision as the primary reason, you cited this decision as one of the primary reasons for the legislation because, I quote, could render the district liable under the CPPA for activities that until now were routine provisions of services and funds that the council did not intend to be the subject of the CPPA. In a letter to you, Mr. Chairman, dated November 26, 2024, Mayor Bowser and Attorney General Schwab also asserted the May versus River East decision, again, specifically targeting 6 Black women low-income first-time homeowners by the Court of Appeals as the justification for the need of the emergency and temporary legislation. In a successful scare tactic, Mayor Bowser and Attorney General Schwab argued that the May litigation opens, quote, up the district to potential massive CPPA exposure without enactments of the bills. The district government could be subjected to broad liability beyond its role as a governmental entity with grant-making and lending authorities, which could significantly blunt the district's participation in the affordable housing marketplace. Before I continue to speak on the issue of this legislation and its undeniable attack on the 6 Black women low-income first-time homeowners that my firm is privileged to represent, I think it's helpful to understand the ruling of the Court of Appeals. In its unanimous decision, the Court of Appeal highlights that in 2007, this council amended the CPPA law to include nonprofits. And later, in 2022, which at this time, you will note, Chairman, that all of the current council members, with the exception of Felder, Parker, and Fruman, were sitting legislators, clarified in 2022, clarified the CPPA to exclude the housing authority. If there was a great concern for liability of the district, it would seem to have been logical and timely that this council would have clarified the full intent of the legislation, specifically as it relates to housing in the district, but it did not. In fact, Mr. Chairman, 10 of the current 13 members of the council, as it exists today, voted yes, with 9 of the members acting as co-introducers of the DC Housing Authority Emergency Amendment Act of 2022 that sought to clarify the role of a quasi-government agency in providing housing. Additionally, I can find in no committee report or council discussion the issue or concern about the liability for the district. Was the District of Columbia not providing housing in 2022? Right, as stated in the need for the legislation in 2024, they wanted to, and the significant potential liability from the district, did we not have the same liability or potential for massive liability in 2022? Were there so many lawsuits and so many decisions by the courts subjecting the district to this massive liability that it would not have been prudent and the responsibility of this council and administration to look at this liability before passing and signing the legislation in 2022? I would argue that if it was so significant in 2024, it would have had the same level of concern for the district in 2022. Mr. Chairman, I think it's worth noting that our clients filed a lawsuit on January 29, 2021, over 20 months prior to the previous 2022 amendment to the CPA or clarification of the CPPA. Nonetheless, it was not until 6 Black low-income women in their first homeownership opportunity did this administration and this council abuse its legislative power to punish and retaliate for exercising their constitutional rights. To further understand the intent of this legislation and its intentionality to punish these women, we agree with the Court of Appeals that in their finding of no evidence in the legislative history of the CPPA of the council's intent to exclude the district's liability under the CPPA in a circumstance where it is directly acting as a merchant. I encourage each member of the council to read the order issued by Judge Rigsby with great attention before making a decision to vote on this legislation, and to understand that this legislation is targeting 6 Black women for having a dream of being first-time homeowners. The emergency was because of the posture of the current litigation, and the permanent legislation is to secure the heavy arm and the heavy hammer of the district's power. I've been paying attention, Mr. Chairman, to the actions of Congress regarding the district, specifically concerning specifically the current concerns we all have regarding the continuing resolution to avert government shutdown. The language in that bill effectively repealed DC current budget, forcing a return to the prior year's spending levels. So while in the current year, Congress would like to move the goalpost and say that you have to change your funding to the previous year. I've watched press conferences where I've heard you, Mr. Chairman, and the mayor and others talk essentially about this as abuse of power from Congress as it interferes with the rights of the district residents. How going backwards, moving the goalpost backwards in the budget will require substantial cuts and impacts on the lives of district residents. I can't help but think of the irony of this statement as I sit here today, knowing that the council, at the request of the mayor and the AG, passed by an overwhelming majority to not only pass the clarification in the language of the CPPA, but just like Congress, you will move the goalpost retrospectively to 2007. I agree with the Court of Appeals, and I agree with the Court of Appeals, and I do not agree with the narrative of the administration and the AG about the flood. I agree with the Court of Appeals and not with the administration and AG about the flood of liability that will be created if this legislation does not become permanent. It's simply not true, and there is no evidence of it being true before 2022 when there's clarification, and in the 2 years since 2022, Mr. Chairman. In a posture of caution, I can see clarifying the language moving forward, but it is an egregious, unconscionable, unforgivable, and quite frankly, hypocritical vote to do so retrospectively, knowing that it specifically and intentionally impacts the lives of 6 Black women whose only role in this situation was to become first-time homebuyers. I believe that I have heard public statements from almost every member of this council, the mayor and the AG, regarding the situation of the residents at Talbot Street. It is without dispute that each of us, and I've heard you say it as well, Mr. Chairman, feel compassion for the horrible situation that these district residents have been subjected. I think we all agree that it's horrific and that our clients and all the residents of Talbot Street deserve better. I would argue that based on this council's unanimous recent decision to expel Councilmember Trayon White, that each of you also believe that we should be responsible for our actions and held accountable to the people and the public trust. That is why it's hard for me and my clients to understand why at the same time you are changing the law and moving the goalposts such that the district should not be held accountable for its actions. Should the public, specifically residents of Ward 8, trust this council to act and pass laws that are in the best interest of the residents? Or should they live with the reality that you can trust the council only until they want to change the law and move the goalpost? How can residents ever have a chance to win if the rules of the game continue to change and the only players on the field with the playbook also have the power? If this administration does not want to be treated like a merchant and held accountable for its actions, it's very simple, Mr. Chairman. All they have to do is stop acting like a merchant. The council's oversight role is a tool that is meant to represent the people and make sure that the administration is held accountable for its actions. I would like to thank and note Councilmember Robert White for his efforts in support of the residents of Talbot Street. His actions have been consistent with his words. Thank you for your time this morning, Mr. Chairman, and the consideration of my testimony. I urge each council member to vote no on this legislation, but if you feel compelled to protect some black hole of liability, some massive potential liability that has yet to be proven, I believe you have a responsibility to remove the retrospective provision. I'm open for any questions you may have, sir.
Thank you, Councilmember. Thank you for your statement. We don't have a copy of it if you want to provide it.
Okay, yes, sir, I can provide it for you.
All right, thank you. Before I begin with a couple of questions of you, I do want to say this, and I should have said this at the beginning. I have some familiarity with the situation with Talbot Street. I believe that all of the roughly 46 homeowners were first-time home buyers. I believe all of them received economic assistance from the city because of their income status or economic status. I think that what happened to them with the buildings, I think at this point, being condemned is horrible. The It is a source of frustration with me that we have builders who are building properties. We see this around the city that don't meet code and disadvantage oftentimes homeowners, in this case, sometimes renters, with shoddy, substandard, in this case, even uninhabitable property. I do want to note that the city has provided assistance. I'm saying this really just for the record. The city has provided assistance to the homeowners of varying amounts, but generally, maybe I shouldn't say generally, sort of the same amount. It depends on when the rental assistance began, and in some cases, the rental assistance, not some, in all cases, the rental assistance was for the rental units that the homeowners were displaced to, so that was of varying amounts, but generally the same amount of assistance. And if I remember correctly, I think the total assistance that the city has provided is several $1 million. Plus, going forward, a commitment to provide first-time homebuyer subsidies to the home purchase assistance program, even though technically they're not first-time homebuyers since they already bought first. But it's really, really been very unfair what has happened to them. So I just want to acknowledge that. And I guess I could add just a little bit more. The city has as a policy to try to preserve and create more affordable housing. And we, as part of that policy, want to see more home ownership because that is a way of building wealth if that's what an individual or a family wants. So it's just been really, really unfair what has happened. Councilmember, has a court ruled that the city is actually liable here?
No, sir. What happened in, I think as you noted, Mr. Chairman, we filed an action of negligence and violation of the Consumer Protection Action against the district in the lower court. They were both dismissed. We appealed them to the Court of Appeals. The Court of Appeals upheld the decision for the dismissal on the negligence claim, but reversed and remanded the decision as it relates to violation of the Consumer Protection Act. And that reversal and remand, Mr. Chairman, doesn't say that the district is liable. It just gives us an opportunity, right, to make a determination whether, or to have a trial or a jury to make a determination whether or not the actions of the district actually constitute negligence or constitute a violation of the act.
Sure. So we don't actually know, as a matter of fact, that the district acted improperly. I do.
Correct, sir. And I think that it's not to cut you off, Mr. Chairman, but I think that's worthwhile noting that this moving forward, right, with the opportunity to take this back to the lower court doesn't automatically mean that the district, it's like anyone else, we're innocent until proven guilty
Sure.
in many ways, Mr. Chairman. And so what's been taken away through this legislation is even the opportunity to make the determination of the violation.
Sure. So I want to note that the Director of the Department of Housing and Community Development, who's not testifying today but did submit a statement, said this in the statement, it's not very long, to clarify, the district provided a loan to the developer of the residences, but DHCD's capacity as a lender of funds did not extend to the actual building of the properties. How did we know, without knowing, of this liability or potential liability under the CPPA in 2022?
Say that, can you rephrase that question for me,
Sure.
sir?
How did we know, without actually knowing, that of this liability in 2022?
Gotcha. So I think that it's not necessarily, Mr. Chairman, about knowing about this specific liability in 2022, although, I would argue that there's some notice around it since the lawsuit was filed in 2021, right? That there's some notice that there are residents of the district that believe that the district had liability because of the lawsuit, right? Like, so it's like any other notice provision for a premise liability claim or any other claim, right? Once you have notice,
Sure.
but
Was the district's the sole defendant in the
the
suit?
district was not the sole defendant.
And there were multiple claims that were made by the plaintiffs.
There were multiple claims against multiple defendants.
Okay.
Yes, yes.
And the suit was not served on the council,
The suit was not served on the council. The suit was served on the District of Columbia.
which means I'm assuming the Attorney General.
It means I'm suing the district and they're represented
Sure.
by the Attorney General. Yes, sir.
Sure.
But I would say that to really be more specific and answer your question about how would you know in 2022 if you didn't know in 2022, it would seem to me, right, that in 2022 when this council was considering the intent of the legislation as it relates to DC Housing Authority, which is a housing provider, right, that in that contemplation of thinking about the provision of housing either from a quasi-government agency or from a government agency, you were thinking about housing and liability, right? And so obviously the Housing Authority is not the only housing provider, it's not the only funding source for housing in the district. The district is also. And so I think that it seems somewhat logical that if the intent of the initial legislation, as this council's posture is, right, especially to backdate it to 2007, if the initial intent, if the intent in 2022, if the intent in 2007 was to make it so that the district would never be a merchant or not have liability, then that should have been a part of the amendment or the clarification that the district made at that point in time. It wasn't, Mr. Chairman, until this litigation, right, specifically about this litigation, that the council and the administration decided to do this additional clarification.
Sure, I could argue that differently. I don't know if there's a value in that. So I think I'll refrain from.
We can agree to disagree. We can agree to disagree, Mr. Chairman.
Sure. Let me see if I have any other question.
If I could say, Mr. Chairman, you stated
Sure.
that the district has put in millions of dollars to this project. Obviously, we are still,
When I say millions, I was speaking to assistance to the homeowners who were displaced, to rental assistance, moving assistance. And then I think there was a buyout offer recently. And I'm not sure home purchase assistance so far. I don't know if that's part of that total as well.
and so, and I mentioned that, Mr. Chairman, because we don't either. So although the district is not a party in the litigation currently, they're a third party, and obviously we did third-party discovery, and we continue to get information from the district. But I think that maybe it will be helpful for you, Mr. Chairman, and definitely helpful for us to get an understanding. We also, our clients and all of the 46 residents received a letter from the district saying, we helped you this much specifically, and we helped all of you all to the tune of whatever that amount was, $10-15 million. And we've asked for an itemization of where's that, like, tell us the itemization of that for each one of our clients and the itemization of that generally speaking, and we've been unable to have that provided for us. So we would request, Mr. Chairman, if it's possible for you to get that answer to be able to provide for us, that would be significantly helpful.
Let me see, I'll ask.
Thank you, sir. And Mr. Chairman, we have never denied, we do not deny the district has provided some support, right?
Sure.
And so that this isn't about whether or not they've done nothing, right? This right here, this legislation that's being proposed as you introduced it, sir, is about not about whether or not the district has provided support. It's about whether or not the district can be held liable for its actions. And again, I encourage you for you or your staff to really take a deep dive into Judge Rigsby's order from the Court of Appeals. What she's saying is, generally speaking, she agrees with you, and we agree with you that generally speaking, the district is not a merchant. What the district does as a jurisdiction in providing funding and providing housing, generally speaking, sir, that does not qualify as a merchant. But in this specific case, under these specific facts, right, that's when the district moved from being a municipality into being a merchant, therefore creating the merchant-consumer relationship for which just like any other merchant in the district, allows for an opportunity for a jury or a judge to make a decision on whether or not their actions violated the law.
I'll let you have the last word. Thank you. Thank you for your
sir.
testimony.
Thank you, sir.
I'll turn now to the government, Caroline Van Zyl, Solicitor General, Office of the Attorney General. Give me just a moment before you start. Thank you. When you're ready.
What do I need to?
Yes.
There we go. All right, Chairman Mendelson and members of the Committee of the Whole, good morning. I'm Caroline Van Zyl, the Solicitor General in the Office of the Attorney General for the District of Columbia, or OAG. I appreciate the opportunity to testify in support of Bill 2645, the Consumer Protection Clarification Amendment Act of 2025. This bill would clarify the definition of merchant in the Consumer Protection Procedures Act, or CPPA, the district statute protecting consumers from businesses' unfair and deceptive practices. The council previously enacted clarifying legislation in 2023 that the CPPA applies to the DC Housing Authority's landlord activities, but that the clarifying legislation, quote, shall not be construed to otherwise apply to the District of Columbia or any agency thereof, end quote. The present bill would once again make clear that the definition of merchant in the CPPA does not include the district, its agencies or instrumentalities, or any employee thereof acting within the scope of the employee's official duties. It still authorizes suit against the DC Housing Authority for its activities as a landlord. The CPPA is an important tool for the district government to protect consumers from unfair and deceptive business practices. OAG, for example, routinely uses the CPPA to help district residents who have been deceived or misled by unscrupulous businesses. For the last decade, our Office of Consumer Protection has investigated potential violations of the CPPA, brought civil enforcement actions where appropriate, and offered a free mediation program for consumers and businesses to resolve disputes without going to court. The CPPA also gives consumers the authority to bring a private right of action. Given the harm the CPPA is designed to address, courts may award strong remedies for violations of the CPPA, including treble damages, punitive damages, and attorney's fees. The CPPA applies to merchants. Importantly, for purposes of this bill, merchant is defined as a person, whether organized or operating for profit or for a nonprofit purpose, who in the ordinary course of business does or would sell, lease to, or transfer, either directly or indirectly, consumer goods or services. Historically, the district has not been considered a merchant. This has been recognized, as you noted, by the DC Court of Appeals, which in 2008 held that the district is not a merchant for purposes of the CPPA. In that case, the Court of Appeals explained that the district is not a commercial enterprise and did not enter into a consumer-merchant relationship when providing public services or enforcing the law. Until last year, this holding stood unchallenged. However, late last year, in a case called May versus River East at Grandview, the DC Court of Appeals held that the district was a merchant, exposing it to potential financial liability. At issue there was the Housing Production Trust Fund, one of the district's major tools to ensure affordable housing. Administered by the Department of Housing and Community Development, it uses public funds to provide grants and other financial assistance to private developers to help them construct and preserve affordable housing and help lower-income purchasers afford new homes. Although the trial court promptly dismissed the claims against the district because the district has never been considered a merchant, the DC Court of Appeals recently reversed, upending the decades-long understanding that while private parties can act as merchants, generally the government does not. That decades-long understanding was correct. The district is not like a private company. It does not generally sell or supply consumer goods or services in the ordinary course of business. Rather, it carries out governmental functions. Unlike the sale and supply of goods and services, governmental functions should not be subject to CPPA liability. Further, creating liability under the CPPA for the district as well as its agencies and employees could seriously threaten district programs and funds in the future. If the district is a merchant under the CPPA, it could be sued whenever a recipient of public services or funds believes the district omitted information or was in any way misleading, even in making aspirational statements or setting goals. Consider, for example, a statement by DC Public Schools that students will graduate from high school college ready, or a promise from the Department of Public Works that all plastics will be recycled, or a statement that the district aims to make its roads safe for bikers. Similar representations by companies have been found to be actionable under the CPPA, and a lawsuit along those lines could cost the district millions at a time when its budget is already strained. Already, other consumer protection suits are pending that could create serious fiscal burdens, such as a suit against DC Lottery for allegedly publishing the wrong winning lottery numbers by accident. That suit alone claims around $340 million in actual damages, and if you consider tripling the amount and adding attorney's fees, the potential financial exposure is profound. And that is just one lawsuit. This legislation is imperative to protect the district from unwarranted liability and also to reinforce the council's legislative intent. In the aggregate, the district's potential exposure to liability could be enormous, and this is not a result that we believe the council ever intended. It is, as far as we're aware, unprecedented in the long history of the CPPA, and as far as our research reveals, it would make the district an outlier among jurisdictions with similar consumer protection laws. It simply makes no sense that the council would ever have thought of the district as a merchant. Instead, the council made clear just 2 years ago that the CPPA's provision of liability, quote, shall not be construed to otherwise apply to the District of Columbia or any agency thereof. By further clarifying the CPPA's scope, the present bill would protect the district and its employees from unjustified financial exposure that we believe the council never meant to authorize. Finally, the bill does not preclude other remedies in situations like the ones faced by the homeowners in the Meg case. For example, if affordable housing is defectively built, generally home buyers can sue the private developers and contractors who are responsible for the defects. Similarly, the council, the mayor, and the agency administering a public program can provide appropriate assistance. This can furnish more effective, efficient, and timely remedies than a lawsuit ever would. For all these reasons, OAG strongly recommends that this committee advance this legislation, and we encourage the entire council to support the passage of Bill 2645, the Consumer Protection Clarification Amendment Act of 2025. I would be pleased to answer any questions.
Thank you, Ms. Van Zyl. I'm going to begin with this. Is there still litigation pending that would constrain to some extent how much you could talk about the court case?
Unfortunately, yes, there is. The May case itself is still pending in front of the DC Court of Appeals, so there's a limited amount of information I can share.
All right, just procedurally, so the Court of Appeals made a decision, but the case is still pending?
That's right. So at present, we have filed a petition for rehearing both with the panel and with the full court based on our view that the panel decision was erroneous for a variety of reasons, and also based on the intervening legislation. The plaintiffs have moved for some additional time to respond to that, and I believe that their response is due sometime in May. So in legalese, the mandate has not yet issued. That case is still live. There are still proceedings in front of the DC Court of Appeals.
So the court hasn't granted the motion en banc, or?
They have not. They're awaiting a response.
Okay.
They require opposition before they can rule to grant.
Okay, but again, because it's pending, there could be some constraints on how much you could say about the case.
That's exactly right.
Could you say a bit more about why there's this language you cite from 2023 that the council said shall not be construed to otherwise apply to apply the act to the District of Columbia or any agency thereof. If that language is there, did the court overlook it?
So the court did acknowledge that language, but somewhat puzzlingly, it found the language to be both, uh, this is my characterization of it, somehow ambiguous, and also perhaps confined to the landlord provisions of the act. Candidly, as we've said in our papers in that case, we think the language was already pretty clear. But obviously the Court of Appeals, or at least this panel of the Court of Appeals, took a different view.
Not that this is on point with this legislation, but what is the liability of the housing authority? Is it just in terms of its landlord-tenant activities? Because it does rent apartments to individuals,
That's
but it
right.
also does things like participate in rebuilding housing projects. So what's the liability?
My understanding is that it's limited to its liability as a landlord, although I'm not going to claim to be the foremost expert on this, but I do think it's a rather narrow provision.
Okay, I mean, just I don't know if this is a question, but just it sounds to me like it's landlord-tenant relationship, like if I'm renting from a landlord, how the landlord chooses to rent or advertise to me, but not with the housing authority building a new project, constructing a new building. Just thinking that's somewhat analogous to the situation with Talbot Street. Give me just a second. Ms. Van Zyl, you were present when I was asking questions of the previous witness. Was there anything in that exchange that you would want to comment on?
So I suppose the only thing that I would want to respond to is this allegation that this legislation exists sort of specifically for the purposes of the May lawsuit. And I would just say that that's not how I view things. I mean, what the Court of Appeals did was state a general rule of law that'll apply in all cases moving forward. And I mentioned in my testimony another case pending that has nothing to do with affordable housing regarding the erroneous announcement of the wrong lottery numbers. And I think that that case illustrates why we think this sort of broad fix to bring the statute and the interpretation of the statute back in line with the council's original intent is necessary, because as to any plaintiff, we think that the council had not intended for the district to be treated as a merchant. And so I would hate for the record to characterize this fix as something that's tailored to one particular lawsuit or one particular set of plaintiffs. I think if the DC Court of Appeals had handed down the same ruling in a case involving the lottery or any other agency, we would be here offering exactly the same perspective.
That the Court of Appeals in its panel decision opened the door in a
Exactly.
way that makes the district liable in many cases, which we have not yet seen, but will likely see.
That is our concern. Prior to the May decision, we viewed the law in the district as being settled, that the district was not a merchant. And I think there was little incentive under that regime for plaintiffs to come forward and try and sue the district because, again, in our view, the law made it fairly clear that we were not liable, that we were not merchants under the CPPA. But once a court announces that the law has shifted, I think that creates a different situation. And so I do think that our concerns about liability, about new plaintiffs, new suits involving different sets of facts, I think that that to us is what causes this concern that goes well beyond the confines of any one case.
So the lottery suit, which is several $100 million, is one since the May decision. Are there any others that have been filed that you know of?
Not that I'm aware of, but that doesn't necessarily mean that they don't exist. I just have not done a survey of all the pending Superior Court cases.
What about prior to May? Between the case I had cited that you mentioned, I think it was Snowden in 2008. Been any other Court of Appeals rulings since then, or maybe trial court rulings since then that were consistent with Snowden? In other words, reinforcing.
That the district was not a merchant for CPPA purposes. Obviously, in the May case itself, that is what the trial court had ruled, which was then reversed by the Court of Appeals. I can't recall other cases off the top of my head where we were sued. Again, I think that might be because the Snowden case had a bit of a deterrent effect when you have something on the book saying that we're not a merchant. I think that would deter most plaintiffs. But certainly if I become aware of any cases, if the council is interested, we can always send you a list.
Okay. Anything else? I don't think I have any other questions for you. Let me just double check. I double checked. I don't have any other questions for you.
Thank you so much.
As I noted, the record in this case, for this hearing is open for 2 weeks, closes at 5 p.m. on Thursday, April 3rd. Anybody, including you, Ms. Van Zyl, wants to submit a statement or testimony or supplement, has 2 weeks to do so. I want to thank the witnesses. The time is 11:26 in the morning and this hearing is adjourned.